once London's evening newspaper, now London's evening newspaper website. Tristan has made a point of exposing other kinds of courts to open up other courts to secret hearings that occasionally occur. Now, some of you who have heard me banging on, and Robert as well, talking about how justice has to be seen to be done, this is an example of where, in parts of the justice system, it is not, has not been seen to be done. This is where pioneering journalists have actually opened up the system, have brought the concept of open justice into some of those more hidden corners of the judicial system. And they're going to talk to you about some of their stories, some of the things they've found out, some of the things they've shed light on, because that's the job of the journalist, to shed light on things. And then I will possibly ask them some further follow-up questions, and then we can open it up to discussion. So I'd like to hand over, first of all, to Sanchia Berg, and she's going to take the podium.
Thank you very much. Right, so I may not be very quick in lining up the slides, so thank you very much. But first of all, to introduce myself, I have only just a few weeks ago left the staff of the BBC, and I'm going to be going back freelance. I have for many years been a BBC correspondent, mostly a reporter on the Today programme, BBC Radio 4, which I hope you've come across, even though some of you may not have been studying very long, because in the UK it's often called the most important broadcast news programme. It kind of sets the agenda for the day, it has big interviews, all the working journalists that I know listen to it. So it's a really significant programme. It's, of course, a fantastic place to work, because you really are the kind of face of news. You really are making news every day. So that's where I spent most of my working life. And as part of that, I learned about the family courts. Most people know almost nothing about the family courts, even though they have the power to have the most drastic impact on people's personal lives. These are the courts that decide whether children should be taken away from their parents, placed in care with foster parents, or maybe placed for adoption, which will change so many lives forever. In fact, it's such a significant thing that one of the most senior judges said about 12 years ago that it was equivalent, in his view, to the death penalty. He said, now that we no longer have capital punishment, a family court judge has the power to have the greatest impact on people's lives, because it may sound sort of mundane, children's social care, etc., but if you think about what it must be like for a child being given a completely new identity, not really knowing who their parents are, and on the other side, for those parents, the extended family, having your child taken away, it's such a terrible personal, emotional experience that even if people have neglected their children, they often feel very upset, and they feel that there's been some kind of miscarriage of justice. And that's why reporting family courts is so important. Because over the years on the Today programme and elsewhere, I've been contacted repeatedly by parents who say to me, you won't believe what's happened to me in the family court. And you know, they're not even, or they haven't even, before this point, able to talk to me, because family courts were so covered by a particularly draconian Act of Parliament of 1960 that it meant parents couldn't even talk anonymously about their case. So what's happened over the last 3 years almost is a real change, and I think a real opportunity for journalists. But as I say, I think an awful lot of people don't know what happens in the family courts. And in fact, when I first went into a family court 16 years ago, I barely knew what was going on. I knew that as a journalist, that was the point we were allowed to go into these courts. I knew they were very important. But when I tried to follow cases, it was just incredibly difficult, because there are processes, I think, they're so used to being unobserved that the lawyers and the judges just go about their business, often leaving the parents behind, and it's very, very hard to follow. So what changed this? Why are the courts now starting to open up? There's been enormous pressure, because there's been a lot of very bad publicity about family courts as parents come forward and say that they're biased, that they need to be opened up. Some judges were saying they needed to be opened up. And journalists like me were saying that they needed to be opened up. So just over, nearly 3 years ago now, some of the judges decided to try a little experiment in open justice in just 3 cities, Cardiff, Leeds and Carlisle. And what happened there was they experimented with a kind of new court order called a transparency order. And that's a really important thing for journalists, because what that does is it allows you to report what you see and hear in court. It allows you, crucially, to talk to the parents involved in cases, and it allows you access to court documents which will fill in a lot of vital information, or, if when you report, you can keep it anonymous. Now, this experiment was backed by a handful of top judges, and lots of other judges were deeply sceptical about it. They didn't want it, lawyers didn't want it, other people involved with the court system didn't want it. But we went up to Leeds, myself and a senior producer who's very good at this kind of stuff, and we followed cases in Leeds Family Court for about 3 weeks, and it was really extraordinary to see how they worked, how people were dealt with. There were certain things that we reported that really struck us. I should probably pull up the article here so you can, as quite, not necessarily miscarriage of justice, but innately unjust, like the fact that a mother who hadn't looked after her daughter very well was told her little girl was going to be placed for adoption, and then she was told a certain therapy might help her, but that therapy couldn't be delivered by the NHS, or certainly not in time. And so she never got a chance to see if it would have worked. And her little girl's been adopted. So these heartbreaking, awful things happening, and we were the first journalists to be able to report them in a meaningful way. And once we published and broadcast our reports, I'm going to see if I can find this now. Here we are. So we headlined, as you'll see, on actually a mother who did get her baby back. She'd had 4 babies, one after the other, taken away from her because the courts had said she couldn't safely look after them. And then she managed to do an awful lot of work on herself, really, therapy that she did online and things like that. She convinced the court-appointed psychologist that she had completely changed and she could have her baby back. So baby number 5 she managed to keep, but there were lots of other people whose stories didn't end quite so well. And as I say, this was the first time that anyone had been able to follow cases like this in this kind of detail. And you'll see that we had to anonymise all of these as we went. So that was a significant thing because it showed the skeptics within the system that journalists could be trusted to report accurately and carefully without identifying people. And it also showed our editors, because lots of people were very interested in this. You know, it was one of the most read stories the day it was published. There was a huge appetite for stories about the family court. So on we went, and I followed a number of other cases. I'm not going to put them up here, but they were all fairly high-profile cases. And one of them set a really good precedent. And this is not my report. Let's see this one. This is my report, hopefully. Except it's come up. Yeah, I think it's this one. Yeah. So this I did, as you can see, in May 2023. I went to the High Court with PA and the Daily Telegraph to get the right to get papers from a past family court case. And that was important because there was a criminal case running at this point in time of the 2 parents of this very cute baby who had murdered him once the family court put him back in their care. So when we got the family court papers, we could understand how on earth that had happened. We could show there's enormous public interest in covering these kind of stories because you can make sure, or make sure that people know what happened and hopefully stop it happening again. So this was the Finley Bowden and precedent case, and we reported other cases as well. In fact, one case that I followed in Cardiff Family Court, which I reported in early 2024. I'm not going to give you too much technical information about the court, but there are different kinds of cases in the family court. Now, this story was actually not a public law case, it's a private law case, but all you really need to know about this is that a mother paid out a lot of money to go to her local family court to strip her ex-husband of parental responsibility for their young daughter, and that's because he had been found guilty of raping other children, but the way the law is, you still retain the rights, parental responsibility over your own children. So that means the right to be consulted about their health, their medical care, ultimately to have contact with them. So this young mother was terribly worried what was going to happen when her ex-husband came out of prison. So that's why she went to court. Now, Harriet Harman MP heard my piece, read the piece on the website. She rallied other MPs to get the law changed. And actually, yesterday, the government published the latest version, which is changing the law to ensure that parents in that position would never have to do that again. So that's a really satisfying thing as a journalist, that you report something, somebody powerful hears it, laws changed, children protected. So we went, and these are very important individual stories, I would say. I would encourage everyone to take an interest in family court reporting. It's still quite new. It's only been extended to all courts in England and Wales. It's only extended at the end of January this year. So it's still kind of bedding in. It's quite hard to find out about cases. But it's two things, really. There's a very powerful public interest in knowing what the state is doing to people's families. This is being done in the name of everyone. It's, I think, vital to hold it up to public scrutiny. And then the other side of this is that it casts a light on sides of society that are generally hidden, that people just don't know about. So, for example, very specifically, this is my last example. And I will just tell you a little bit about this. Have any of you seen this story? About the three babies?
Yes.
You've seen it. You've seen it. So this is a really unusual, extraordinary story, and this is how I got it out of the family court. So I saw that one baby had been abandoned in January 2024, and I knew that where that happens, that was going to have to come before a family court, because a local authority can't simply take a child. It has to be permitted by the local family court. And I happened to have made contact with that local family court for something else anyway. So I found out when the hearing was. I went along to the hearing, and when I was in the hearing, and I got the documents, which you can get through the transparency order, and just to reiterate, a transparency order is the tool that we use to report a family court. It allows you to report what you see and hear, get the documents, talk to the parents if they're there. So in this case, it was about the documents. And those documents show that there had been two other babies found in very similar circumstances, not far away. And those two babies were full siblings. So then the question was, could Elsa be a full sibling of those other two babies? Now, in that case, the local authority and the children's guardian Kafkas didn't want me to report this at all. So I could only report some other bits of information initially. A PA news reporter who's very sharp saw that I'd reported on the case, and he found out about the next hearing. So we were there together for that one, and we put in joint applications. And I'm sure Terry will tell you, this is quite unusual for journalists to have to do, to stand up in court and actually make applications, or even write a legal application and put it into the court. But it can be done. It's not, it's essentially about being up for it, thinking that it's important enough that you should do it. So we put in these applications, ultimately we were successful, and we could report this link, which we and the judge believed, because she found in our favour, was very much in the public interest. Because how can it be in a city like London, that most heavily surveilled city, it's often said, in the world, how can it be that parents have abandoned 3 babies less than an hour after they were born in public places? So being able to report that, something that would never have been reported before, is one of the other benefits, I think, of reporting family courts. And the way that we reported that, the fact we kept on reporting it, going to every court hearing, meant that the police decided that they would change what they were doing, because they didn't seem to be doing anything from what they said to the family court. And they let us into their inquiry, and we were able to follow that. So it was all a really good sequence of stories, which just wouldn't have been told if I hadn't gone to the family court case. So where we are now, all family courts are open to transparent journalists with transparency orders. You have to have your court recognised press card to go in. It can be very difficult to find cases. If any of you going forward in your course, if any of you are interested in doing it, I'd be very happy to talk to you about the mechanics of it, how you can start, how to go about it, because I think it's really important that this kind of doesn't get forgotten or neglected. There are so many pressures on journalists, Tristan will tell you, I'm sure, and editors have so many other things to worry about that family courts can often get kind of left behind. But these are things that are so important to people's lives. They're very popular stories, but they're also very important stories. So I really would urge you to take an interest in this. And I don't know if it's on your curriculum, Terry, but I know that Holly in Sheffield is trying to put it on hers and get the NCJ to put it on there. So, I hope that you found this interesting, and I hope that you see that it's important. And if you're interested in reporting family courts, I'm very happy to help you do that. That's my bit.
Thank you very much. Thank you very much, Sanchia. We'll come to some questions generally in a minute, but I just wanted to ask you one thing, just pick up on what you said. Is there any kind of online resource to explain to journalists and would-be journalists about the transparency of it and how to apply them? There is.
There's quite a lot on the judiciary side about the technical side. There's also, I've written about it, Louise Tickle and Hannah Summers, I think, have written about it as well. So there isn't quite a how-to guide, but there's quite a lot of useful information. And I think the big thing is to do it step by step and not to be scared by the prospect of doing something new. But also you have to be very mindful that identifying people, that's not just a question of putting their name in, it's also a question of worrying about jigsaw identification, which I'm sure you're dealing with in the rest of your course.
I think Robert deals with that. And maybe Law. Okay. Tristan.
Lovely.
Thank you.
First of all, thanks very much for having me. It's always lovely to speak about these things. My day-to-day life, I usually sit in the corner of the court saying absolutely nothing if I can avoid it. So it's always nice to bang on about something that I think, as Sanchia said, is incredibly important. I'm the course correspondent for the Evening Standard, which is now the London Standard or the Standard, depending on which medium you access our material through. So I'll stick with the Standard. I've been there since 2016 as the dedicated court reporter, now correspondent. Before that, I spent time as an agency reporter based at the Old Bailey back to 2012. So all in all, I've been doing it for a while. At the moment, my role involves going to any and all courts and tribunals around London, sometimes beyond. I get to go on foreign trips to places like Stockport, really nice. So, there's a lot to aspire to there. But I pick up cases that are deemed to be interesting, important, no matter what jurisdiction they're in. I thought I would talk predominantly about the criminal courts, which is obviously separate to the family courts, although there is occasionally a rather sad and tragic crossover in particular cases. The criminal courts, the family courts, as just been explained, are sometimes tricky. That's not to put you off from exploring them, but they are sometimes a difficult place to go to get a story, and there can be obstacles, as just been talked about. In my view, the criminal courts should be the exact opposite of that. You should be able to wander into a criminal court and sit down, and even if you've never had any kind of training whatsoever, you should understand exactly what's happening in a criminal court, because they are public courts and they are there for everybody to understand and appreciate what's going on. Not least the defendant, who will more often than not have any kind of legal training, but will still be listening at the back to what's happening in their particular case, and they're obviously at the centre of a lot of those hearings you go to. I'll talk to you as well about something called the single justice procedure, which is an area of particular interest. That's was that now, in 25, to report on the criminal courts, it will be said by some people that they have never been more open, there's never been more access and availability to information. Journalists particularly have open access to information like never before, and there are publications online of rulings, sentencing remarks, listings, things on reporting restrictions. There's all kinds of access to information, and a lot of that is true if viewed through a particular lens. But I would say that, in my experience, the challenges to open justice, the principle that justice is open to everybody, the challenges are perhaps as big as they've ever been. And you could certainly mount a parallel and contrary argument that the criminal courts in this country have never been more secret, which seems like a strange thing to argue, that they're at the same time more open and yet more secret. So let me explain. When you go into a criminal court, and some of you have, as I do every day, you go in, there should be no challenge to you coming in, it's an open court, and as a reporter I'll sit down and I'll listen to what's going on. You're sometimes met with the kind of bureaucratic obstacles that you get when you go into a court, people asking why you're there, who are you, and it seems somewhat hostile that you're there, but as I say to all students that I come across, you're there to do a job, you're there to report on the courts, and you are nowadays the eyes and ears of the public, because by and large the public don't go to court. Sad, but true. They're no longer the soap operas of the public, and people only really go to court if they know somebody involved in the case and they particularly want to find out what's going on. So the press are there to obviously inform people about them. What are the challenges? Well, you start off looking for a criminal case. Say you all were looking to go to a criminal court. You look up the listings of the particular case. Something like this. This is just a normal listing of a Crown Court. So you look at that. And these are published online, so that's good. But as somebody coming new to a court and wondering where to go, you ask yourself, what does this tell me? The answer is almost nothing. Although it looks like a good piece of information and it's published online, and they can say, oh, look, we published online, it doesn't tell you anything at all about the case. It doesn't tell you what the people are charged with. It doesn't tell you what stage the trial is at. You can glean some little bits about there being an application for bail, or a trial or something like that. Take the case at the top. It's one of the little quirks of the system. It's a trial in court 2 in front of a High Court judge, so a serious one, and the name of the defendant is starred out. That might lead you to think that you can't identify the defendant. There's some sort of reporting restriction contained. There is a reporting restriction. I won't go into the details of it. It involves a child. But the defendant is in his 40s. There's no reason why his name should be starred out like that, but it is. Just one of the things that we live with in the court reporting arena, that sometimes there's a layer of secrecy applies for no good reason, and there's nobody within the court looking to kind of overturn those things. So they can say, we publish these things, but we don't really tell you things that are going on. The single justice procedure is an aspect of the criminal courts that I've reported on quite extensively over the last few years. And I wouldn't blame anybody in this room if they have no idea what it is. But it is a process by which people can be prosecuted for crimes. And looking around the room, this is the process, the criminal court section, that all of us could find ourselves in. Which nobody's sitting here thinking, I'm the criminal, I'm potentially going to find myself in a court or prosecuted. But every single person in this room could be prosecuted, and there's a likelihood of it, for speeding, for not paying for a train fare correctly, for falling behind on your TV licence payment, for not getting a rod licence when you go fishing, for all manner of low level crimes. That's what the single justice procedure deals with. It is the majority of criminal cases in this country are dealt with in the single justice procedure. And let me tell you some features of this process. It was invented in 2015 as a way of doing things quicker, faster, cheaper. None of us can go and watch it. So, as I was explaining before, criminal courts sit openly, except they don't. In the majority of criminal cases in this country, you can't actually go and watch them, which comes as a surprise to a lot of people, but that's the way it was invented, to do it faster and cheaper. If you want to find out some information, so you become interested in the single justice procedure, and you want to find out what's going on, well, let's see what they publish. No, that's the wrong one. I knew I'd fall down there. Oh yeah, there we go. Right, so this is today's single justice procedure listings. As you can see, there are 1,278 cases to aim at. Excellent news. And what can we learn about these hearings that we're not allowed to go to? Well, for a start, unlike in the Crown Court, which is obviously the more serious cases, we see in the Crown Court, apart from our man who's starred at the top, we can see the full name of the defendant. Not so in the single justice procedure. You're only allowed half the name and an initial. And we're only allowed half of their postcode to find out where roughly they're from in the country. And this is the police force that's prosecuting them. And this is the charge, so this is a speeding charge. And that's it. That's all you're allowed to know. You're not allowed to know any more information, such as how fast were they going, where were they speeding, what were they driving. I'm not suggesting anybody's going to be particularly fascinated about a speeding case. But bearing in mind, there might be a lot of B. Evans, as in the W1 area, who might be concerned that their name has been put out there and accused of speeding when it's not actually them. That's how these things work. This is a particular charge using a handheld mobile phone, driving whilst on the phone, something that people care about. All in the single justice procedure, all behind closed doors, inaccessible to the public. Journalists have special access to this system, and I've been somewhat praised over the last few years for getting access to the single justice procedure, investigating it. But to my mind, it's not investigating at all. This is just actual access to information to be able to report on stories. And some of the things that are happening within the single justice procedure, as it turned out, are incredibly concerning. It's not just cases like this that, let's be honest, they look fairly standard, people speeding. Do we need to know a little bit more about them? Here's some of the things that were uncovered in the single justice procedure. It turned out that people were being prosecuted in the single justice procedure when they were incredibly vulnerable. Homeless people being taken to court for not paying for a TV licence. Look into the details if you will. There are a plethora of these ones. A woman here, you can see from the headline, she was taken to court by the DVLA for not insuring her motorbike, when she was being detained under the Mental Health Act. She was in hospital and basically fell behind on her bills, prosecuted and convicted in the single justice procedure in a closed court proceedings where the public have, as I say, almost no access to any of the material. And for journalists, for people like myself, it is rather hard to get access to all of the information that makes up these stories. You put it on a screen like this and it looks like it's been rather easy, and look at all these stories that you can publish. But each one of these stories involves a disclosure process where you apply to a court for various pieces of paperwork that you want. Before you do that, you have to try and guess, essentially, which cases you might want to look at and which cases might elicit the kind of stories that you know are happening within them. People, you know, in hospital. I was just looking one before I came in here of, I'll be reporting on it soon, of a pensioner with dementia who is basically incapacitated now and has been convicted of not keeping up with her car insurance, which astonishes me that nobody's stopped these stories. I started writing them back in August 2023 and assumed that the government would do something about it. But here we are in October 2025, nobody's done anything about it, and I'm a very stubborn man, so I continue to write these stories on the grounds that if they don't do anything, I'll keep doing it. But anyway, that's what the single justice procedure can elicit if you look into it. It's a system where I know that the courts have been given magistrates targets of the number of cases they have to get through in a day. So it's very, very fast, very, very rapid. As I say, you can't go and watch these hearings, so there's no scrutiny of how they're actually coming to these decisions. All in all, generally, it's a system that is terrible. But I decided it was something that was well worth looking into because it's where the vast majority of crimes are prosecuted, and it could potentially be the thin end of the wedge. If you allow a system like this to take hold within a society, then the people in power will say, great, we can do things cheaper and we can do more like this. And they tried to. There was something called the online plea and allocation system, which was invented a few years ago. And it was intended to be based on the single justice procedure, everything behind closed doors, done on paper, magistrates just sitting, agreeing things amongst themselves. And they were going to do that for cases going up to the Crown Court, so that some parts of the criminal justice system, the hearings that I go to and get stories from, would suddenly be behind closed doors. And there was a media campaign, and thankfully we saw that off, and they decided to not do it, blaming lack of money, which, let's be honest, there is no money. But it's still on the statute book, and it could come back, and they could do it in the future. So I think there needs to be vigilance of that, because who knows where we'll go next. On the horizon is a big reform of the court system, where they're going to take away jury trials for certain crimes, and make them into magistrate and judge deciding on guilty or not guilty. It's all part of a drive to make things faster and cheaper. And if they're thinking along those lines again, then why not get rid of some of these hearings that I go to and just do them administratively? It's one of the biggest bugbears I have in courts when they do things administratively, which means secretly. And before I stop talking, because I've gone on for it, I just wanted to say things just generally about the way that courts operate in the modern era. Now, in this day and age, we have a digital case system within the criminal courts. It's very good for the people who have access to it. They can share documents, they can, everything's contained within one computer system. Everyone has access to it. Everyone except journalists. And so we can't see it, but there is an increasing reliance on this system. An increasing amount of times when a case will come into court, it's a sentencing hearing, so defendant's in the dock, judge is going to pass sentence and needs to get submissions from the relevant barristers. The prosecutor stands up and says, Your Honour, I've uploaded a detailed note to the digital case system, so I'll take this shortly. And then they will briefly summarise what a 20-page note says that the judge has already read. And then the defence will stand up and say, well, I think we can short-circuit this. You've seen my note, and I'll say X, Y, and Z. And then the judge passes sentence. And everybody in the room, presumably including the defendant, knew what those notes said. And then the journalist has to then go through what can be a cumbersome and annoying process of trying to get hold of those documents to be able to properly report the hearings. Next week, I shall be standing up in court hopefully not embarrassing myself, making an application to a judge for the documents for a hearing that took place in June. And I haven't been able to report that hearing yet because I couldn't get access to the documents. And the disclosure process has left me now making an application. That's what is caused by reliance on digital systems to the exclusion of the public, and therefore to the exclusion of, the exclusion of the press, and therefore the exclusion of the public. And I think that's an incredibly important cause for everyone to campaign on, because, as I said at the beginning, courts are only open if we are able to report what's happening in them. And what's happening at the moment is basically secrecy by mistake, through reliance on digital systems and accidentally, or perhaps deliberately, taking things behind closed doors, behind the firewall, and we're not able to report it without going through lengthy disclosure processes, which frankly you might not be able to do. A story is a story on the day it happens, and if you have to report the sentencing without access to the notes, so be it. Anyway, thank you very much. I hope
that was very interesting. I have a number of questions for both of you, and just to open up the discussion. Can you tell me, are the justice, this closed system, is this in court? Does it actually take place in a court?
No, I mean it can do. It's a closed court, so
Yes.
the single justice procedure by law has to happen in a closed environment. Sometimes the magistrates will be sitting in open court, and then they'll say, okay, well, we haven't got any cases, we'll deal with some single justice procedure, lock the doors, or more often than not, they will sit in an office and do it on their computer.
But these are exclusively magistrates' courts rather than high courts.
Yes.
Yeah. Okay.
At the moment.
Because those charges are all relatively small ones, as you pointed out. So it is.
Yes.
It was designed as a means to speed up the small cases going through magistrates' courts.
That's true. Although I will say, and I didn't mention it, that it was pitched in 2015 as essentially cases that nobody cares about. And then come 2020, the pandemic arrived, and almost all of the COVID regulation breaches were prosecuted through the single justice procedure, which really blew a hole in the idea that it was for things that nobody cares about, because obviously people cared a lot about that.
About the breaches.
Yes, absolutely. There were 10, 12, £14,000 fines being imposed for these hearings.
And do you have any idea how many document submissions there will be in each case? You know, they're going through a lot of paperwork for each case that they're looking at.
So because this is a semi-public arena, I wasn't able to show you the documents, but generally, if somebody is accused of, let's take speeding, you get a letter through the post saying you are going to be prosecuted, and it'll be like a 15-page document which sets out, you've been charged with this offence, here's our evidence, which is like a statement from the police and maybe a picture of your car going past the camera, and then there'll be lots and lots of papers explaining how to enter your plea online, how to enter a guilty plea, what will happen then, how to enter a not guilty plea, what will happen then, and then some dark warnings about what happens if you don't engage with the system. The vast majority of people don't engage with the system, so you don't know until you ask what's available. But if somebody enters a plea, then you can get hold of that, and you can also get hold of their mitigation, and that's where a lot of those stories that I was posting, that's where those stories come from, is somebody who's charged with not paying their TV licence, and then they write in, plead guilty, and then write, I'm really, really sorry, I was in hospital having my leg amputated, and my TV licence expired, and I didn't mean to, and that's where those kind of stories.
And you access those documents by special application.
Yes, you have to make a disclosure application, and one of the things that I did many years ago was work with HMCTS, the court service, to build a system whereby this was like acknowledged that we could do it, because when they invented it, they didn't like think of how the press would have access to these things. So we built a system to get access to it at a time when I wasn't really writing embarrassing stories for them. I was just writing about celebrities doing misdemeanors. And then they have a sort of a one day where they have to comply with the disclosure, and then there's set documents that they can supply to you, and so that's sort of set in the guidelines.
And are these cases where people are both pleading guilty and not guilty?
Yes.
Or so it could be either.
So if you plead not guilty, then your case goes to open court. That's automatic.
Right.
So you can't have a trial within the single justice procedure.
Right. So it's for people. It's only for people who plead guilty.
And critically, for people who don't plead at all, then you have what's basically a mini trial, whereby the paperwork for the prosecution is put forward, and then the magistrate looks at the paperwork and then decides if you're guilty or not. You've not engaged, so the chances are you will be guilty.
And physically, where are these taking place? In magistrates' courts all around the country?
Yes.
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 And how many, you may have mentioned it, but how many are taking place at any one time?
Oh, how many cases?
Yeah.
It deals with something like 800,000 cases a year.
800,000 cases a year.
Yeah, that's in the context of 1.3 million cases in the criminal courts each year. You've got over 800,000 in the civil justice procedure, then you've got a big portion of the rest in the magistrates' court, and then you've got a very small proportion in the Crown courts.
And do they refer cases upwards if they feel there's something concerning about it?
They can, but generally they don't.
No.
So the case that I mentioned that I'm going to write about, somebody was prosecuted for not paying for their DVLA bill. I think it was insurance, car insurance. Their daughter wrote in and said, my mother has dementia and she's now in 24-hour care and is incapacitated. That was then entered with a guilty plea, but if you take a step back, somebody can't actually plead guilty to an offence that they mentally couldn't have committed. So there's problems there. I don't know, I'm not a lawyer, so I won't make a determination. But the magistrate had a choice at that stage. Do we accept the guilty plea and impose a conviction on a pensioner with dementia, or should we refer it back to the prosecutor to say, are you sure, or potentially refer it to open court for a more considered in the round decision? And that magistrate decided to convict, rubber stamp, and that's a conviction, and there's a sort of a penalty, and that is there on a person's record. For me, totally the wrong decision, and is indicative of a system which is built for speed and for just getting things done rather than actual justice.
Okay, thank you. That's absolutely fascinating, I think. I just want to ask both of you really, you work to expose different bits of the system, open up to public scrutiny. Could you, Sanchia Berg, just describe what kind of resistance you've met? I mean, is this an easy passage, or have you found it very difficult to deal with the court system and get information and to introduce these processes? You've got this transparency disclosure business. I mean, would you say that was the easy thing to get out of the court system, or was it really hard work?
I think there has been such criticism of family courts, as I said, that senior judges had decided they were going to try this out because they said public confidence in the system was crashing. So they said to restore public confidence, we are going to have to let the journalists in, warts and all, and try to rebuild confidence in the system. But of course that wasn't shared by everyone through the system by any means. I think most judges were resistant to it, certainly that's what I was told. And I also, on the very first day of what was supposed to be this new transparency in Leeds, Katie and I went up to, I think it was General Clark, who was sitting in the corridor between several different courtrooms of Leeds family courts, the big, ugly, modern building. And she obviously had the papers for the cases in front of her. And we said, we're journalists, we're here for the transparency pilot. Can you tell us what cases are happening in the different courts? Because of course, we knew, and I knew from my previous efforts to report family courts, that without information, this just wouldn't work. So we asked her, can you please give us a little bit of information about these cases? And she looked at it and said, oh no, they're private, because this is a private court. It is different from the cases that Tristan's talking about. It's not an open criminal court. But the whole point about the transparency orders, as I said, was to trust journalists to report family cases in the way that we're trusted to report cases involving vulnerable people or children, that we can safely anonymise people. So I'd say it was pretty difficult, actually, to be honest. I mean, we ended up, almost giving up on it because we couldn't find cases, and then we managed to persuade some of the listings people to give us a bit of information about the cases, and that enabled us to find and report cases in a meaningful way. When I say a bit, I just, for example, is this an emergency hearing? So when you're looking for family cases to report, you need to know that there are an awful lot of types of hearing where really nothing happens, but they schedule the next hearing, expert reports and things like that. So you need a hearing which is either starting a case or concluding it, really. And an emergency hearing would be the start of the case. It might mean, for example, that a local authority was trying to take a baby away as soon as it was born because they thought the mother couldn't care for the baby at all. So if you're trying to find a case to report, an emergency hearing is a good place to start. But they wouldn't even tell us that initially. And after a period of time, and I think it's now, in fact I know it has now improved quite a lot, they're now giving a little bit more information. But as Tristan was pointing out in the listings there, it isn't easy. You have to be really determined. You have to say, I think this is really important, and stick with it. And there have been some journalists, like there's a Welsh journalist who has done some really good stuff. But it takes persistence, because this is new and there is an awful lot of resistance. Yes, still.
Yeah, Tristan, you found resistance, I assume.
Well, I think it's part of life, and to an extent, there is always going to be a certain amount of resistance. In 2017, 2018, there was members of the media worked with HMCTS, and something I think is really good and important was create the HMCTS media guidance. I encourage everyone to look it up, because it is sort of like the bedrock of what we can have access to across all of the courts. And it was, I think, the first time they really properly set down in writing what we could have access to, what we couldn't have access to, and for the staff to be able to know what we were asking for. But I mean, that was 7 years ago now, and I think that the process hasn't really evolved as I would have liked it to, because once you've set the bedrock, then you start talking about access to documentation, as I was saying, reporting restrictions, and the kind of accelerated access to information that you really need. And then you also, you do come across judicial, what's the word that insult people, but ignorance. I think it's probably a better word, because judges don't necessarily know how we work and what we're entitled to and what we're not entitled to, and that all of the staff and to an extent the lawyers within the room, they take their lead from the judge. And so if a judge has a misguided understanding of what we have access to, then that informs everything else, and so you come across this sort of inherent resistance. We've just actually, as of earlier this month, got in place a new rule which says that whenever somebody in a criminal court wants to apply for a reporting restriction, so say somebody wants one of the witnesses to not be identified, then they can apply to the court, but they have to tell the media in advance of the application so that we can contribute. I called it a new rule. It's not actually a new rule, it's always been the case, but we needed a new rule to enforce the fact, because nobody ever did it. And I'll tell you, we had to go back to the committee twice that makes the rules to convince them that this was something they needed to do, because a lot of judges sat around and went, we don't need that. it's already sort of baked into the system. So we have to go back and say, well, nobody ever does it. So you need a rule now to enforce it, and then we'll see how that progresses in terms of the actual application.
Yeah.
I also think there's a difference between some of the judges in the Royal Courts of Justice, for example. There's some really strong judges who are very much in favour of open justice in the family courts, and what happens at the lower levels. There's one case that I'm following in, I won't say where it is, but it's in the southeast, and it's unbelievable the way that case is being handled, and the way that everything about it, from me getting access to many papers to even ensuring safety in the court centre. It is really a completely different world, and you probably find that too, looking at magistrates versus,
Yeah, I mean, they're
just
very
being
different.
cheap or something.
Yeah, very different way that the magistrates operate compared to the Crown Courts. I will say that the kind of access and openness that you get comes with trust. It shouldn't, but once you become established and known to judges and lawyers and officials, you'll find that transparency grows because they feel like they can trust you. As I say, that's not the way it should work, but the way it does work, and occasionally you'll get an email from a judge saying, would you like to make an application for these reporting restrictions to be lifted? It's a great day when it happens, because you pretty much know that they're going to lift the application, the restrictions.
That's amazing. Before we open it up, I've got one further detail I just want to show. Some of my students who are encouraged to go to courts have already experienced the delights of the court serve information overload, where you just have absolutely no idea what any reference and case is about. But I want to ask you about the one you highlighted, where the name of the defendant was blocked out because the case involved a child.
Yes.
Was it not blocked out because of the issue of identification of the child?
Well, I mean, that's a live trial, so I'll talk in generics or past cases. Sometimes the system for listings works where if a reporting restriction is applied, then the name gets starred out as an automatic, regardless of whether that should happen or not. And so what you can get is a reporting restriction saying you cannot identify this child witness, and then that is then applied to the adult as well, because of the way the digital system works. So it can't distinguish between not identifying a witness and not identifying a defendant.
But isn't the case that if you identify the defendant, it could identify the child?
No.
No.
No, I would resist that in the strongest possible terms, because it depends what you say. It would be like saying that if you have a case involving a man who assaulted a young boy. Take that as an example, okay? So I can identify Bob Smith assaulted a young boy, or is on trial for that, right? Now, anybody listening to me is not going to tell me that I've just told you that Bob Smith assaulted his nephew, right? You can't possibly have known that from me saying Bob Smith assaulted a young boy. But what you needed that extra piece of information for that to make sense. So it cannot possibly make sense that if you anonymise a child, you have to anonymise the adult, simply because there is a familial relationship. You need that extra information. That's why when we report those cases, we can report them in a way you can report the adult, the defendant, the person accused of the crime, without then breaching the order on a particular child, if that's the circumstance in the case. So I would always say that there's a sort of an imperative, if possible, to be able to name defendants, because they are the person accused of a serious crime, and if they were to be convicted, there's a public interest in people knowing who they are. We sometimes end up in a situation where you can't, they make an order to say you can't name the defendant, and sometimes those are cases involving sort of child sex abuse, and I would say that's a terrible situation to be in, where there is a potentially very dangerous offender who could go on trial, be convicted, spend a period of time in prison, come out and nobody will be any the wiser of what they've done because it was never able to be published, that this is the defendant.
Fascinating, thank you very much. Okay, open up to questions. Let's have some questions, please. Anybody? Yeah.
So I was really interested as well
Please speak up,
in the family court. I hadn't really thought about the reporting of that or how it would be different to the criminal courts completely, and I didn't know anything about the like the transparency thing that came in. What was the law that prevented it before, like and was it because of so many children involved and like the ethics of obviously reporting children?
Yes, essentially, it's the Administration of Justice Act 1960, and it basically makes it a contempt of court for anyone to even talk about the case. So then, you know, if you're a parent and you feel that there's your children, for example, have wrongly been placed with their father who you think is a danger to them, and you think the court didn't do its job properly, as you know, until the transparency regime came in, there was really almost nothing you could do about it. It's still limited because if you could contact a journalist while your case is ongoing, then we can jump into it, we can get a transparency order, we can follow it, we can get all the documents, and we can report it anonymised, but we follow it and see if it really is a miscarriage of justice. But of course, mostly people don't say that until the whole process is completed. You can get papers from past cases, but you have to go to the High Court, and it can be quite difficult. So there's still work to be done, I think, but it's, yeah, no, it was impossible to report anything meaningful about family courts until this transparency came in, because you could sit in the courts, but you couldn't actually report anything meaningful unless you could only report what the judge allowed you to.
So does the transparency, the new transparency order, does that mean that it kind of overrides parental permission? Because I suppose there might be in some cases where the parents wouldn't want something
Well,
about
they
them.
don't have a right. So essentially, the 1960 Act means nobody can talk about it, nobody can report it. And what I think is extraordinary, really, about this transparency order is it simply says it doesn't apply. I didn't know they could do that. They could just say it doesn't apply, but with these conditions. And those conditions are what you'd expect, not naming people, not printing photographs, and so on. You know, very exceptionally, in the Baby Elsa case, we were allowed to use the photographs because the real identity of those children isn't known. So we had to vary the transparency order so we could publish the photographs. So all these things are quite complicated. You have to kind of figure them out on a case-by-case basis. But basically, the Act made it, as I say, nobody can talk about it. Parents don't have a veto over reporting of cases. What will happen is, let's say you've been invited possibly by a mother who says, this is awful, you know, please come and follow my case. And you go into the case and the father doesn't want you there, which is quite likely if the mother is the one who contacted you. And then he has to, or his lawyers have to stand up and make an application, explain why you shouldn't be there. But the judge does have the right to, in exceptional cases, refuse to grant the order, but it's supposed to be the default position that you get the order. So I haven't had anyone been turned down for an order so far. But I have to say, you know, it's kind of early days, and there are lots of judges who have never had a journalist in their court. So it is all new.
But the presumption is one of access.
Well, the presumption is that you get the transparency.
You get the
And you know that, and then that sets certain conditions which allow you to get the documents, talk to the parents, and report what you see and hear, but all provided you keep it anonymous. And that's a very different thing from what we had before, where kind of oddly we could go in court as journalists into a family court, but if we wanted to report anything, we had to ask the judge's permission. So for most judges, they would just say, oh, you can say it was this kind of case or something. You couldn't say anything meaningful. So it is a really enormous change.
Right, next. Sorry, did you have your hand up there?
Yeah, I had a question. I'm sorry, I'm not completely sure if my question would fall under any of your jurisdictions, but I was kind of curious on how it goes in journalism when it's about, and also in the law, One is about discrimination or exclusion of minority groups. I mean, in the really extreme cases, I don't know if you saw the Panorama documentary about Charing Cross, where police agents basically said that migrants are a problem and should be shot, to make it really, really extreme. But for every story that gets told, there's like 100 that doesn't get told. Like I've personally had experiences where I tried to go to the media of the story and they were basically like, yeah, I'm sorry this happened to you. If you can find 100 more people where this applies, please bring them to us and maybe we'll look into it, but otherwise I'm sorry. So that's the media side of things. And when it comes to law, do you know if discrimination is a punishable offence or not? And if so, how that goes also with reporting on it?
So we're not lawyers.
No, I know.
I can tackle that one though. I think you were being generous when you said for each one that you hear about, there are
Yeah, I know.
100 you don't hear about. There are thousands, and you'll find them in the magistrates' court by and large, and unless there is a particular dimension to them, then you'll largely find that they're not reported on. Cases where police officers have done, the defendants, they tend to get sort of picked up. But if it is generally the man in the street, and you know in the midst of a row or whatever they're doing, discriminates against somebody, uses offensive language, that can end up in the magistrate's court and it won't necessarily end up in the pages of a newspaper. Those kind of cases, there are various different provisions of the law that they'll come under, but you could find the Public Order Act. Section 4 is a public order offence where you've basically done something that made somebody feel harassed, alarmed, or distressed. There is a racially or religious aggravated version, I think that's Section 5 of the Public Order Act. There are other kind of offences that you can commit that are racially or religiously aggravated crimes. So these kind of things, I do see them, not just from time to time, all the time, going through the courts. And I think whether they end up in the page of the newspaper depends on the agendas that are going on at the time, what people are interested in, what people are not interested in, and you know, I mean generally whether somebody is notable or not. I can say a lot more about what newspapers do and don't pick on, but perhaps I shouldn't.
That's for another forum, I think.
Can I quickly ask a follow-up? Do you think that is undermining the public trust and faith in the system?
Which system?
Well, like the like basically in journalism itself, and also in the basically the judicial system as well.
I think it has the potential to. I don't mind saying that. At the moment, there are certain groups who are picking up on criminal cases, and they are presenting them as if they are brand new, as if this is a new phenomenon going on, something perhaps that's not necessarily potentially controversial, maybe a bit more anodyne, is the idea of shoplifting. If you read the papers this summer, you'd think that shoplifting had suddenly burst into this epidemic, and you know politicians have uncovered this thing that was going on secretly that nobody knew about. So I can tell you that shoplifting has been a mainstay of the courts for many, many years. Potentially there's more going on at the moment, potentially there's not. But if you read the newspapers, you'd think that this was sort of like this massive surge of cases. It's not the case. And so, yeah, it depends what kind of agendas are going on. It does have the potential to undermine faith in the justice system, because sometimes people are being presented with an incorrect picture.
Yeah. Mina, and then Mina, yes.
Thank you both so much for sharing your experiences and insights. I wanted to ask, you've both clearly demonstrated such a sort of nimbleness and understanding of legal systems, law, acts, the things that govern a lot of the work you're doing. And I kind of wanted to understand, you know, where does your role personally as journalists or professionally as journalists, where does that sort of merge or end, and sort of the legal side of things, or being a lawyer kind of takes over? Or I mean, you both said you're not lawyers, but where does the sort of balance come in, sort of where do you step back and say, okay, this is my role as a journalist, and this is where I now need to, you know, call the cavalry and sort of hand it over to the lawyers to kind of work with me?
It's a really good question, actually, because I don't know what the standards policy is, but PA increasingly, for example, they encourage their journalists to try to make their own applications and so on, whereas within the BBC, traditionally, they've got a very strong, supportive programme legal advice department, and the lawyers would quite often call on, albeit not the most experienced barrister, but call on a barrister to support. And the whole point of this transparency initiative is, while on the face of it, it asks the journalists to do something they're not familiar with, it's actually supposed to be manageable for journalists to do. It's not supposed to be complicated. You know, the language of the transparency order is pretty clear and simple. There isn't anything complicated about it. You know, it's only referencing a couple of acts, which are the 1989 Children Act and also the 1960 Act. So it's not that difficult. So I don't feel that it's kind of a big stretch. But I'm always slightly concerned when some of my colleagues have turned up with, you know, a solicitor and a barrister, and I'm thinking, you know, because if it becomes expensive, then people just won't do it. And I mean, and also a lot of these stories are of particular interest to local audiences and local readers. So, for example, one story I did was about children who it's the most dangerous and most vulnerable children in care. So, for example, boys who are involved in gangs and so on. They can be very expensive for the local authorities because children's homes don't want to take them and foster parents can't look after them. So there was one boy who was 13 and his care was costing the equivalent of, I think, £840,000 a year, and he wasn't even kept safe there, and the place wasn't registered with Ofsted. In fact, he used to go away and come back covered in blood, somebody else's blood. So, you know, this was not a safe place for him at all, and it was costing the local authority so much money that a local authority manager gave evidence in court that it was pushing the council towards bankruptcy, as well as the council. So, you know, she had a number of other cases like this, I think about 32. So there's a case that's of real interest to a local audience, because if the council is going bankrupt and cutting lots and lots of important local services, that affects everyone. So a local outlet is not going to be able to bring a barrister to court, or even to go to a solicitor and say, what do you think of this application? So I think to get what we should get out of this as journalists doing our job in the public interest, I think we really have to try and do this on our own, hopefully with support from other journalists who've done it before, rather than resorting to legal help.
I mean, speaking as an ex-crime correspondent, I learned an awful lot about the law when I was doing that job, just in the course of what I did, and you pick up an awful lot. Have the standards supported you in terms of the, you know, if you needed any legal help? Have they done that, or have you done all of this on your own?
Well, I don't want to make the standards seem terrible, but I don't think I've ever instructed a lawyer. I always do it myself, or I will, if another publication is sending down a barrister, then take a step back, because there's no point, you know, wading in knee deep. Publications don't tend to have that much money swirling around for barristers. Media lawyers are notoriously expensive. Sometimes, you know, publications will chip them together and get one, you know, sort of as a group, which is always good. And frankly, I think judges respond better to barristers than they do to the exact same arguments coming from a journalist will suddenly be looked on slightly sniffily, potentially. But having said all that, I don't know why. I think maybe I wanted to be a lawyer and just never had the funds to actually go into it. And so I've always just sort of encouraged everybody, get up on your feet. The arguments that you're going to be putting forward aren't actually that complicated. They might seem it, But really, you're the guardians of open justice. It's a strong principle, and there are, 2 or 3 cases that you can point at to say open justice is really important. The Judicial College guidance, I recommend it because it basically says a lot of good things about why justice should be open, and there should be a presumption on openness. You only, in the criminal courts, you really only end up arguing against orders. Section 4.2 Contempt of Court Act, Section 11 Contempt of Court Act, potentially Section 45 and Section 46 of the Youth Justice and Criminal Evidence Act. You see, I've done them all, quoted them all, but they're all set out. They're all very simple, and you look at the provisions and it says, an order can be made if there is clear and cogent evidence of X, Y, and Z happening. And you look at the papers and you say, well, is that the case? Do I think differently? Argue it. It isn't as hard as it might imagine. McName's Essential Law for Journalists, if you haven't got it, it is the essential book to rely on. And also you do find yourself in court a lot of the time in sort of like a team on the press bench. So you're not alone, you can all collaborate. It might be you watch somebody else do it a few times, then you kind of have you go yourself, I'm a bit of a know-it-all, so
I think you also need to have that confidence to take these people on, as it were. You had a question.
I had a question for both of you, if that's okay. I guess I'll start with Ms. Berg. From my understanding, a transparency order is sort of like temporary, and I know we're in the very early stages of this new transparency order for the family courts, but based on the sort of recent success of it since January, do you see this order moving towards official legislation?
So this has all been done by the judges within existing legislation. It doesn't need a new law to make it happen.
Doesn't the primary legislation?
Yeah, and what's quite interesting about that is over the years, you'll be unsurprised to hear that various ministers have looked at family courts and cabinet secretaries of state and so on have said that we must change this. They've made noises, but they've never actually done it. And it's the judges who push this through. And as Terry was saying, without the need for primary legislation, they've done it. It's not temporary in the sense that it applies for the duration of the case. But I guess, they could say, just as they brought this in without legislation, they could equally say, no, we're going to take it away again. So I think it probably would be a good thing if there was some kind of clarification of permanence. I think that's an excellent point.
Yeah.
And then for Mr. Kirk, in the sort of single justice procedure database that you showed us, it all seems to be very vague. My question is, how do you figure out which court cases are worth reporting on, and what information are you able to gather before you decide to pursue a case?
So the listings that I showed you were the public listings. As journalists, we can ask for access to a spreadsheet which is more detailed information, which sets out name, date of birth, address. This is the case actually for all criminal cases, but this is what you get: name, date of birth, address, what they've been charged with, a little bit of the detail of what they've been charged with, and then if it's the register that you get after, then you've got the details of the sentence. So what am I looking for? That's sort of like a golden question, because it depends. You could be working for a local paper and you want to report on people speeding down a particular road. It's like a sort of speeding hotspot. So you could pull out, it'd take a long time, you could sort of search for key roads, key words within the spreadsheet. What I tend to look for is, not to give away too many of my secrets, but people who the magistrates have given an unusually light sentence to. And then I look to see if there's an indicator on the form whether they pleaded guilty or not. If they pleaded guilty, then there might be some mitigation. So then I could go into those cases and go, okay, well, let's pick out some of those. Then I maybe filter the spreadsheet. I hate spreadsheets, but I've learned to love them. And filter it down to maybe the ones who are a bit on the older side, look at their dates of birth. And so then I might be looking at pensioners who were in a bad situation, And so then, because there are thousands and thousands of cases, so it's very much depends what you're after. Today, I published a story about the Ministry of Justice being prosecuted for not answering letters from the police, and they got a £1,000 fine. So in that one, I was just basically looking at who'd been fined big amounts. £1,000 is slightly above the normal. As I was looking, and then I looked at the defendants, and you look maybe for the old footballer or TV star, and the Ministry of Justice was actually named as the defendants, which, as you might imagine, is a rather unusual thing to happen. So it's a story that I find very, very funny, but also illustrates a lot of things wrong with the civil justice procedure, in that even the Ministry of Justice didn't answer the letters, and therefore there's a big problem with the system. Anyway, there you go, that's for another day.
And when you're looking through stuff like that, you take this sort of mental Rolodex of celebrities and footballers and people whose names might suddenly ping out of a list.
Yeah, it's a bit of a problem for me, because I am growing slightly older, and so my knowledge of who's famous is going with me, and I try to keep up. But basically, when you're looking at hundreds of thousands of names, if you are celebrity spotting, then if I don't know who they are, then they're not famous. So there you go.
Any other question? Anybody else? Yeah, other than that, yeah. Speak up.
Speaking of lawyers, I'm a third-year undergraduate who's studying law. One of my modules was the work placement module, and here we had to do some court observations. I noticed that for some of the higher courts, there seemed to be more used to the idea of people coming in to observe. For some of the lower courts, particularly magistrates or county, but even the Crown Courts as well, there seemed to be some surprise that somebody would be interested in observing. Often there was a large row of seats that were all empty,
Yes.
except me.
Yeah.
And it was and in one of them I wished to take notes, and usually they'd allow this, but for one of them they didn't seem to want me to take notes whilst I was in the courtroom, and I wasn't really sure why. But
Which court were you at? Do you remember? The magistrates' court.
I think it was a Crown.
At a Crown Court.
Crown Court.
Scandalous. Right. Well.
I was wondering, have you faced similar issues?
Yeah, absolutely. Yeah. For a start, I think it's weird that anybody is told not to take notes in court. If they want to take notes, they should take notes. I find that bizarre that anybody stops you taking notes, as if you should just remember it all, and somebody writing things down. I think it was Thames Magistrates Courts. There used to be a sign which said "No reading" in the public gallery. And as I read the sign, I realised I was breaking the rules. I don't know why it existed, but anyway, no reading. Maybe somebody took in War and Peace rather than constitutional proceedings. You're right to observe that. It is absolutely correct. Criminal courts I go into, particularly magistrates' courts, sometimes have vast seating areas and nobody in them. And when that happens, I think particular courts, they get into the mindset that nobody's going to come. And so when somebody arrives, they're surprised, sometimes hostile, sometimes questioning your very existence. But you just have to sort of push past it and say, look, I'm here to do my job, or I'm here to do a thing.
Sorry.
Yeah.
That reminds me, when I went on the magistrates' courts, I was asked if I wished to become a magistrate.
All right.
Yeah.
Wow.
Well, they are desperate. So.
Yes, exactly.
I love it.
Yeah, they were quite surprised as I was there.
I would just say that as a rule of thumb, as a journalist, if a lawyer or even a staff member tells me that the case isn't interesting, particularly a defence lawyer, I will instantly go in and have a listen to it. Because for a start, lawyers and officials and even judges, they don't know what's newsworthy, they don't know what's in the public interest. And if a defence lawyer is telling you that this is really a boring case and you want to look elsewhere, then you have to question what it is that they don't want you to hear. So yeah, I say, and also I tell anybody who wants to listen to me that when you go to court, it's sometimes a bit intimidating. You feel like you need an invite to go inside. I'll just say that as a blanket rule, nobody is going to invite you into the courtroom. It is an open room. It might not feel like it is. It's an open room, so I'd always say go in, and even if you're going for a case that's heard at 11, go in for 10, sit in on everything. Why not? It's an open system. It might not feel it sometimes, but it is an open system.
That's not, I have to say that family courts are not, just to repeat, they're not open. So, you can't just wander in. You can go in, you have the right to be there, but you do have the right to be there as a journalist, so you have to present your accreditation, make sure the judge has seen it, and then that's the way it works. Just on the magistrate's point though, I don't know if you saw there was a really interesting bit of work that Transformed Justice did, it's a little charity, and they were sending volunteers in to observe magistrates' courts, like you were doing as a student, and my recollection was they had a lot of difficulty with the observers. People were told they couldn't sit in and just watch cases.
Yeah, I mean that's the sort of the weird bureaucratic officials who think, I don't know where it comes from, because I mean past guidance that was wrong, but officials who think that you're only allowed in for the particular case that you identify. That's not true. Go in for them all. That you're not allowed to write stuff down. That if you are there, you have to give a reason for being there. You really don't. Yeah.
Our students go in every term.
Yeah.
Generally, they go to magistrates' courts, and they generally seem to. In fact, Maddie here, she was just telling us what a fantastic time she had.
Robert, you had a question.
Hello, this is fantastic, by the way. You mentioned Judicial College.
Yes.
This is the body that trains the judges.
Yes.
Is there, maybe the answer is yes, we're doing it. This is still why they don't obey the rules that they have. But are there journalist bodies, and then maybe trade unions, that liaise with the Judicial College in order to get them to enforce the rules that they already have?
I think the Society of Witnesses does something to do some of that liaison.
So I think the answer is not directly. I sit on what's known as the Media Working Group, which has representatives from the Society of Editors, the News Media Association, various of the sort of the major publishers, the BBC sits on this as well. I'm not entirely sure how I wound up on it, but that's the thing on for dear life. And we have engagement with HMCTS and the Judicial Press Office, and then some of the things that we say potentially goes off to other rooms to discuss, and not a direct link. And there's also something else that's going on that I think is publicly known about, which is Mr. Justice Nicklin is driving a sort of a transparency reform programme, which involves lots of collaboration with various different groups, including members of the media, to try and sort of get opinions on how things are working and how they're not working, and what can be done better. How that actually translates into the Judicial College and all those kind of things, I'm not quite sure.
Thank you. I think it was.
Terry, for the brilliant law student at the back, the case you need to quote that happens again is Ewing against Cardiff Crown Court. But it's a fantastic case to look up anyway. Ewing, E-W-I-N-G, against Cardiff.
Right. Thank you. Thank you very much, everybody. We can continue the discussion outside. I just want to thank Sanchia and Tristan for an amazing.
What do I do now? No, but I need to save.
Come on, Alan.